Are you in family court? And do you know about the Texas disciplinary rules of professional conduct? If you're in family court, you need to know the disciplinary rules of professional conduct. It's the rules, it's the rules in which the lawyers have to litigate by. So, in these rules are rules between the lawyer and the client and other rules that lawyers have to abide by. And I think it's very important that you read the preamble and just some of the chapters in the disciplinary rules of professional conduct so you have an understanding what your rights are between you and attorney and you and opposing counsel if you're pro se. Let's dive into the disciplinary rules of professional conduct set by the Texas State Bar. If you go to Google and punch in Texas disciplinary rules of professional conduct, you might see something like this. The Texas disciplinary rules of professional conduct come from the State Bar of Texas. It's about 117 pages, and I want to go over just a few of these simple rules, but I really encourage you to actually download it or print it or just keep it for your reference. You're going to need it if you're in family court. So if you go to the table of contents, you see a lawyer's responsibility is in the preamble, the scope, and the terminology. And we're going to go over just a few for you throughout this presentation. There's some chapters in here that I really think that will benefit you if you're pro se and you're going through family court. You're going to need to look at chapter 1, client and lawyer relationship, because that's the rules in which the lawyer has to abide by if they have a client. And you, as a client, you need to know what your lawyer's job function is in representing you. Chapter 4 is another chapter. If you're pro se, I would highly recommend that you read non client relationships, truthfulness in statements to others, communication with one represented by counsel, dealing with an unrepresented persons, and respect for rights of third persons. So 1, 4, and 8, maintaining the integrity of the profession. Number 1 and 8 is a must read. And again, if you're pro se, I would throw in rule number 4. Many times parents come out and say, I want a bulldog attorney. I want an attorney that's a bulldog. And it's sad because a lot of parents are going through some issues with their attorney, like their attorney not calling them or responding to their emails. And all of these issues are addressed in the disciplinary rules of professional conduct. So let's go over lawyers' responsibilities. And when I read this, I want you to think every word for word. And again, I'm not going to go through the exhaustive list of these rules. It's for you to research and start reading. But this is just kind of like an introductory into the Texas disciplinary rules of professional conduct for those parents that are going through family court and they might not know what a lawyer's responsibility is to them as a client. So let's look at preamble number 1. A lawyer is a representative of clients, an officer of the legal system, and a public citizen having special responsibility for the quality of justice. Lawyers, as guardians of the law, play a vital role in the preservation of society. When you see or you hear lawyers that are using unethical or illegal business practices upon you in court, then I think you need to understand what their responsibilities are to society. And it says right here, they play a vital role in the preservation of society because they're guardians of the law. A consequent obligation of lawyers is to maintain the highest standards of ethical conduct. Let me read that again. A consequent obligation of lawyers is to maintain the highest standards of ethical conduct. Now, a lot of parents say, well, my lawyer just did it for me. I didn't know what I was doing. He just told me the other lawyer said, and they just came up with an agreement. I need y'all to really listen to these words. As a representative of the client, A lawyer is a representative for you. It says right here, as a representative of a client, as advisor, as advocate. A lawyer zealously asserts the client's position under the rules of the adversary system as a negotiator. So you have a representative, an advisor, an advocate, a negotiator. A lawyer seeks a result advantageous to the client, but consistent with requirements of honest dealings with others. Lawyers still have to litigate consistent with requirements of honest dealings with others. As a representative, advisor, advocate, and it says a negotiator. Nothing says that a lawyer has unbridled discretion to make every decision for you. Let's go on. Let's go to number 3. In all professional functions, a lawyer shall zealously pursue a client's interest within the bounds of the law. Let me read that again. Okay. Lawyers should zealously pursue their client's interest within the bounds of the law. Perjury, aggravated perjury, that is against the law. Okay. So a lawyer can't advise their client to lie. They can't even help their client lie. Does it happen? Absolutely. But this is why it's important for you to know the rules. A lawyer should zealously pursue a client's interest within the bounds of the law. Now, what everybody talks about, my lawyer doesn't call me back. My lawyer doesn't respond to my emails. Again, number 3 in the preamble, a lawyer should be competent, prompt, and diligent. A lawyer should maintain communication with a client concerning the representation. And I always direct parents back to number 3 when they tell me this. And I tell them, hey, just copy and paste number 3, send it in an email. And I can almost guarantee you within 5 or 10 minutes, that lawyer is going to be calling you back. Some of the things we always talk about is how unethical and how these lawyers are using these business practices to weaponize their skill set. And again, we go to number 4, a lawyer's conduct should conform to the requirements of the law. Just because they're representing somebody doesn't mean that they get to break the law. So if somebody's perjuring themselves or they're writing on government documents and these lawyers know that they're lying, then that's an issue. Another big one we see in family court is a lawyer should use the law's procedures only for legitimate purposes and not to harass or intimidate others. In family court, we see it all the time, especially if you're pro se. You're going to get some attorneys that are a little ego driven and they're going to start ramming motions down your throat. And they just, again, want to weaponize their legal skill. A lot of parents say, hey, my attorney's going to drop me and he wants more money. And I always tell them to go look at number 5 and number 6 of the preamble. A lawyer should be mindful of deficiencies in the administration of justice and that the fact that the poor and sometimes persons who are not poor cannot afford adequate legal assistance and should therefore devote professional time and civic influence in their behalf. So if you're making slow payments, I've seen where some attorneys, some of the clients are making slow payments and they're not fast enough for some of these attorneys. So these attorneys want to withdraw. And I always tell them, hey, go back to number 5 and number 6, copy and paste this, put it in an email and see if you can work out a deal. If you go to number 8, neglect of these responsibilities here in the disciplinary rules of professional conduct. Neglect of these responsibilities compromises the independence of the profession and the public interest in which it serves. The Texas rules of professional conduct define proper conduct for purposes of professional discipline. Now, if you go to terminology, go to the definitions, it's sort of like a mini dictionary, right, for some of these key words. And I want you to look at competent, know what competent and competent is. Competence is fraud or fraudulent, knowingly. These are all definitions in which you should know because these definitions incorporated into the rules say exactly what that rule means. We go to chapter one, client lawyer relationship. This is a big one. So if you want to go hire that bulldog attorney, right, these are the rules in which they have to play by. And then plus, it's also good to know what your relationship and what are the rules between the attorney and the client. Let's go over them. A lawyer shall not accept or continue employment in a legal matter which the lawyer knows or should know is beyond the lawyer's competence. Basically saying, hey, don't take a case if you're not a criminal defense attorney. If you don't have never practiced criminal defense and you're a real estate lawyer, maybe you shouldn't be taking those cases. That's rule number 1.01. In representing a client, a lawyer shall not neglect a legal matter entrusted to the lawyer. So if you and the lawyer have already signed an agreement and he's representing you and they are not calling you back, they are not responding in a reasonable amount of time, right? In representing a client, a lawyer shall not neglect a legal matter. So you need to, if you're asking questions about your legal issue, your legal matters, then that's against the rules, neglecting a legal matter entrusted to them. And again, the definition neglect signifies inattentiveness involving a conscious disregard for the responsibilities owed to a client or clients. Competent and diligent representation. There's so many parents out there that say that they didn't have competent representation or the lawyer wasn't prepared. Very, very few. Everyone's entitled to competent representation. So I want to go over this rule. A lawyer's workload should be controlled so each matter can be handled with diligence and competence. So there's some attorneys that don't know how to adequately handle their workload. So sometimes they have a whole bunch of clients and then they can't work on a single case because it seems like they're always in and out of court. So some of these attorneys, this rule is saying that a lawyer's workload should be controlled. Basically, control your workload so you're able to give your clients, diligence and competence that each client deserves. And in family court, we have this issue a lot: neglect. Because delay can cause a client's needless anxiety and undermine confidence in the lawyer's trustworthiness, there's a duty to communicate reasonably with a client. Read or see Rule 1.03. Again, there is a duty to communicate reasonably with their clients. And again, you can put this in that email if they're not calling you, they're not returning your phone calls. Just copy and paste, put it in an email and tell them I'd appreciate if you would call me back because this is a matter that you have been entrusted with and I would appreciate a callback. It's that simple. Again, I'm not going to go over every single rule, every paragraph, but I just want to hit some of these highlighted portions. A lawyer shall not assist or counsel a client to engage in conduct that the lawyer knows is criminal or fraudulent. Those that are following me, interference with child custody is a state jail felony. It is criminal, and a lawyer can't tell the other parent not to turn over the child. When a lawyer has confidential information clearly establishing that a client is likely to commit a criminal or fraudulent act that is likely to result in substantial injury to the financial interest or property of another, the lawyer shall promptly make reasonable efforts under the circumstances to dissuade the client from committing the crime or fraud. When a lawyer has confidential information clearly establishing that the lawyer's client has committed a criminal or fraudulent act in the commission in which the lawyer's services have been used, the lawyer shall make reasonable efforts under the circumstances to persuade the client to take corrective action. A lawyer should not consult with the client concerning any such proposal, and generally it is for the client to decide whether or not to accept it. So, in the scope of representation, if you scroll down, a lawyer should consult with the client concerning any such proposal, and generally it is for the client to decide whether or not to accept it. So, a lawyer should talk to you concerning any such proposals. So if the other side gives a proposal, it's saying that the lawyer should consult with you. Doesn't say they shall consult with you, but it says they should. And I think you should reinforce that. If you hire an attorney, you should talk to your attorney and tell them that they should consult with you anytime any proposal is being made. If you go to 7, criminal, fraudulent, and prohibited transactions. However, a lawyer may not knowingly assist a client in criminal or fraudulent conduct. Sometimes, and what I've seen in Harris County, I've seen attorneys on mute on Zoom yelling to their client on how to answer some of these questions. That's tampering with a witness. You can't have a lawyer assist their client, helping them lie in court, which is aggravated perjury if it's within a court proceeding. However, the lawyer must avoid furthering the client's unlawful purpose. Anytime a lawyer knows that their client has broken the law, they're ethically supposed to withdraw. When a client's course of action has already begun and is continuing, the lawyer's responsibility is especially delicate. The lawyer may not reveal the client's wrongdoing except as permitted or required by Rule 105. However, the lawyer must avoid furthering the client's unlawful purpose. This one goes out to all the parents that are saying, "Hey, look, my attorney doesn't call me back. I've sent them emails, I've put phone calls in, and they just won't call me back." In Rule 1.03, communication, a lawyer shall keep a client reasonably informed about the status of a matter and promptly comply with reasonable request for information. A lawyer shall explain a matter to the extent reasonably necessary to permit the client to make informed decisions regarding the representation. So again, all you parents out there that say, "Hey, my attorney or my lawyer won't call me back. They won't contact me. They won't send me an email." Simply copy and paste 103, 1.03, put it in an email and ship it off, and I bet you'll get a call pretty quick. All these are Chapter 1 client lawyer relationship. Competent to diligent representation, scope and objectives of representation, communications, fees, conflict of interest, general rule, and it goes on. So if you're having any of these issues with your attorney, I suggest that you read Chapter 1. I'm not going to go over 4 non-client relationships, but again, if you're pro se, I would highly advise that you read Chapter 4, non-client relationships. Okay, so now we're going to dig into number 8, maintaining the integrity of the profession. And this rule number 8 is the rules in which they're supposed to follow. So let's go over Chapter 8, maintaining the integrity of the profession. Chapter 8, maintaining the integrity of the profession. 8.01. If you're in family court, this one's a big one for me. Big one for me. 8.01, everybody should know Rule 8.01, maintaining the integrity of the profession. Write this down, screenshot it, print it, keep it with you, because if you're pro se, you are going to have an opposing counsel that will lie on the record. Okay? Knowingly and making a false statement of material fact. So, maintaining the integrity of the profession, Chapter 8, refers to bar admissions, reinstatements, and disciplinary matters. So, this isn't during the course of representation. This is, again, for bar admissions, for you to apply to the bar, for you to be reinstated to the bar, and for disciplinary matters. But I think it's still important to know that just like we've been taught our whole life, knowingly make a false statement of material fact. Lawyers cannot knowingly make false statements of material fact to get into the bar or admissions or being reinstated. They can't make statements of fact they know are false. Um, while trying to be reinstated, and in disciplinary matters. Well, but we know that the state bar doesn't really discipline some of their attorneys. So, but yes, attorneys can't knowingly make a false statement of material fact. Judicial and legal officials. A lawyer shall not make a statement that the lawyer knows to be false with reckless disregard as to its truth or falsity concerning the qualifications or integrity of a judge, adjudicatory official, or public legal officer, or a candidate for election or appointment to judicial or legal office. So lawyers can't really make statements that they know are false. Again, we just went over that. But this is pertaining to the qualifications of a judge, adjudicatory uh, official, public legal officer, or a candidate for an election. This one I think everyone should know. I think is landmark. I would say for any pro se litigant. If you are in family court, okay, we already know about the making statements of fact that they know are untrue. We know about that. When bad lawyers are not reported, they keep using their abusive legal measures or their abusive legal tactics. Let's get into 8.03 reporting professional misconduct. Reporting professional misconduct. A lawyer, a lawyer having knowledge that another lawyer has committed a violation of applicable rules of the professional conduct that raises substantial question as to the lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects shall inform the appropriate disciplinary authority. A lawyer having knowledge that another lawyer. So if your lawyer knows that the other lawyer has issues with honesty, trustworthiness, or fitness as a lawyer, they shall inform the appropriate disciplinary authority. Your lawyer has to report them. Why? Because they have to uphold the judiciary to the highest of standards, but they don't do it. Here is the next big one. A lawyer having knowledge that a lawyer having knowledge that a judge has committed a violation of applicable rules of judicial conduct that raises a substantial question as to the judge's fitness for office shall inform the appropriate authority. If a lawyer sees a judge violating you and acting in ways that could be construed as biased, um, lawyer having knowledge that the judge has committed a violation of the applicable rules of judicial conduct that raises substantial question as to the judge's fitness for office shall inform the appropriate authority. And there's times that lawyers don't want to piss off the judge, so they're going to allow them, and then their client suffers. Their client has to suffer because nobody wants to report the judicial misconduct. But these are important that you know these 8.03 reporting professional misconduct. The state bar is a self regulating profession, which means they police their own. There's nobody else that polices them, they police their own. This is a very bad deal from somebody out in the public. So if you're not a lawyer, if you're not in their fraternity, pretty much you're not going to get heard. But it says it right here. Self regulation of the legal profession requires that members of the profession initiate disciplinary investigations when they have knowledge not protected by Rule 1.05 that a violation of these rules has occurred. So it's up to these lawyers to self regulate their professions, but we all know that they don't do it. When we get to 8.04, misconduct, a lawyer shall not. Remember that terminology we talked about at the beginning? Look for shall. What does shall mean? A lawyer shall not violate these rules, knowingly assist or induce another to do so, or do so through the acts of another, whether or not the violation occurred in the course of a client lawyer relationship. A lawyer shall not commit a serious crime or commit any other criminal act that we already know lawyers are supposed to zealously advocate within the bounds of the law. So, if a lawyer is committing fraud, if a lawyer is perjuring themselves, you need to report it, and other lawyers that are around need to report it. A lawyer shall not engage in conduct involving dishonesty, fraud, deceit, or misrepresentation. A lawyer shall not knowingly assist a judge or judicial officer in conduct that is in violation of applicable rules of judicial conduct or other law. I just went over some. Again, chapter 1, chapter 4, and chapter 8 are some of the chapters that y'all need to read, but especially the preamble. Know the scope of representation. I just made this quick video just to hit on certain topics. It's up to you to read, to study, to know, and then to bring these issues up if you know of an attorney that is weaponizing their legal skill or trying to get a favorable outcome by doing unethical things and not following the rules. Tell me what you think about the video and catch me on the next one.